started. My name is Robert Theofanis, and I am an attorney. I work here in the South Bay in Manhattan Beach, and today we're going to be talking about probate sales. That works. There we go. Okay. I'm a trust and estate attorney. My legal practice includes estate planning, so writing living trust, wills, durable powers, things like that. I do post-death estate settlements. So if somebody passes away and the loved ones need to transfer property, either real property or personal property, and that can take many forms, full-blown probate administration, a trust administration. Sometimes it's as straightforward as a small estate affidavit or a spousal property petition. And then I also handle trust and estate litigation matters. So this would be inheritance disputes, elder abuse type issues, beneficiary rights. So I represent a lot of beneficiaries when they are not the successor trustee or not the executor, and they just want to make sure that things are being handled properly. Today, what we're going to be talking about is probate sales. So a full-blown probate proceeding. So we're in court and we have a deceased person's real property and it needs to be sold. We're going to first go through just the basics of a probate here in California, talk about some common terms. Then we're going to focus in on the two types of procedures. So it's either going to be one of these notice of proposed action or court confirmation. And then we'll take a look at the probate specific CAR forms so that when you guys are dealing with probate transactions, you can ensure that you are using the right documents. So let's start with the big picture. What is probate? Probate is the court process that's required when a person dies holding legal title to property. And when I say the word property, I mean it in the broadest sense possible. Personal property and real property. So real property, obviously you guys are familiar with. Personal property would be bank accounts, brokerage accounts, basically everything that's not real property. So intellectual property is a category of personal property. All your pots and pans are tangible personal property. And so if we pass away holding legal title to property, typically a probate will be required. There's some exceptions, which we'll get to, but that's the general rule. So then the next question is, when is it required? The old rule was that if we had property in excess of $184,500, probate would be required. So if we just had a small bank account, we could avoid probate using a small estate affidavit. Or if we had real property of very low value, we could do either a what's called a small estate petition. There's a new rule, and so I'm going to spend some time on this because it's important for you guys. A new rule as of April 2025, the principal residence of the deceased person, if it is valued less than $750,000, can pass without the necessity of a full-blown probate. And so this is like a game changer because the number used to be so small that here in LA County, it didn't even, it was like 62,500. And so very few real property interests were valued below that level. But here, given the median house price, this is probably like 45% of the properties in the county would fall below this number. And so if you come across a situation where you've got a potential seller and a house that's below 750, you can probably keep it out of probate. It's outside of the scope of today's presentation. I have a separate presentation on it. It's called a small estate petition. A third party is going to be the one who is appraising the house. And so, it doesn't matter what you think. It doesn't matter what Zillow thinks. There's a very particular person called a probate referee, and we need to find a probate referee who will appraise it for less than 750. But if that's the case, the property can be kept out of probate. And we don't have to deal with what we're going to talk about today. That one sort of subtle note there is it's the deceased person's interest. So if we have two brothers who own a $1.2 million house and one of them dies, the deceased brother's interest is less than the 750. And so even though the entire house, the entire real property itself is far in excess of the 750. We're only talking about the decedent's interest. And so that just a subtle point to be aware of. And so then here are the other common exceptions to probate. So beneficiary designation property, if you've got a bank or brokerage account or retirement account that has a valid beneficiary designation on file, that stays out of probate. Joint tenancy property stays out of probate. So take those two brothers. If they held title as tenants in common, then we would need some kind of post-death proceeding or procedure. If they held title as joint tenants, we would not. The surviving brother would just simply record an affidavit of death. And then the final exception is property held within a trust, whether revocable or irrevocable, so long as legal title has been validly transferred to the trust. The death of the owner is not going to require a probate proceeding. So then let's go through the basic steps of a probate. So this all starts with, it's not up there, but step 0 is somebody dies. So we've got somebody who holds title to real property and they're now deceased. What do we have to do? Step 1 is somebody has to go to court and open the probate. The name of the petition will, generally is referred to as a probate petition, but it can be petition for probate, petition for letters of administration. But someone affirmatively has to go to court and get that first filing on place and get somebody appointed as personal representative. The time period between step 1 and step 2 is usually 5 weeks, give or take. And at that first hearing, the judge is going to evaluate the legal sufficiency of the petition. It's going to make sure all the required allegations and all the necessary evidence has been submitted. And if everything is good, we'll proceed to step 3, where the judge grants the petition, opens the probate, and appoints somebody as personal representative. From there, the personal representative needs to take care of some paperwork on their end in order to obtain what are called letters. And we'll talk more about letters, but in a nutshell, letters are the formal legal document that authorizes a personal representative to act on behalf of the estate. Until we have an order appointing somebody as personal representative and letters issued to that personal representative, no one is authorized to act on behalf of the estate. Then from there, we have the creditor claim period. So part of the personal representative's duties and responsibilities involve providing written notice to all known and reasonably ascertainable creditors of the estate. Those creditors have 120 days to file a claim. If they don't file a claim, then they're out of luck. At the same time, the personal representative's duties also include what's called an inventory and appraisal. So they have to create a document that itemizes all of the property within the estate. They send it to the probate referee, who then appraises all of that property. And at the end, a single document is filed with the court that lays out the gross value of the estate. From there, we go to step 5. Ideally, we have assets that exceed liabilities. And so then at that point, the personal representative can evaluate and potentially pay any valid claims that have been filed. And once that has been taken care of, we're ready for final distribution. So if the estate is solvent, assets are in excess of liabilities, then the property remaining in the estate after the expenses of administration will be distributed to whoever is entitled to them. So if we have a will, it'll be the beneficiaries named in a will. If we don't have a will, it'll be in accordance with California intestate succession. So typically that's going to be closest relatives. So if you leave a surviving spouse and children, they will divide the property in some fashion depending on the exact facts at hand. So I've mentioned a few times the term personal representative. Personal representative is the person who is in charge of the estate at any given point. And there's actually, it's an umbrella term, and there's 3 different types of potential personal representative. The first is executor, which I think is the role that most people are familiar with. An executor is somebody who is named in a will. The next would be administrator. An administrator will be appointed if there is no will. So you can only have an executor if there's a will. You have an administrator if there's no will. A special administrator is a short-term job. So imagine the situation where the estate includes a business, right? So real properties, those can usually hang out sort of on their own without a whole lot of risk of loss of value over a period of a few months. But a business requires somebody to run it and somebody to be in charge. And so if the deceased person owns a business, typically that first probate filing will include an additional petition for letters of special administration, which will be heard on an expedited basis and allow someone to immediately take control of the estate and exercise control of that business. If you recall, it takes at least 5 weeks, sometimes much longer, to get somebody appointed. And so it's important when we have a potential for loss to have a special administrator appointed. We talked about letters, and so letters, just like the personal representative, come in different flavors. An executor gets letters testamentary, an administrator gets letters of administration, and a special administrator would get letters of special administration. And again, this is the formal legal document that gives the personal representative the authority to act on behalf of the estate. Okay, then the next, and we're kind of bouncing around here a little bit, the next sort of probate terminology thing we need to talk about is the Independent Administration of Estates Act. In the initial probate filing, the personal representative can request either full or limited powers under IAEA. And the reason to do so is because it allows the personal representative to take certain actions with limited court supervision or with no court supervision. And so probate, the general rule is the court has to either pre-authorize or confirm after the fact basically everything the personal representative does. And so the Independent Administration of Estates Act makes exceptions. So it categorizes certain actions and it says if you have this power granted to you at the beginning of the probate, you can do these certain things without the court involvement. And so personal representatives, in terms of making the administration go as quickly as possible and as smoothly as possible, they want to have full IAEA powers. And where that matters for real estate is as follows. And so now we're into the two procedures. And so it's important to understand the IAEA authority of your potential seller. If the personal representative has limited or no IAEA authority, then we're over here on the right. Court confirmation is required. So I'll say that again. A personal representative with either limited IAEA powers or no IAEA powers is going to need court confirmation in order to close escrow. On the other hand, if you have full IAEA authority, you can proceed with the notice of proposed action procedure and hopefully attempt to avoid a court confirmation situation. It still may be required, and we'll talk about why or how, but that's the difference. And so the question you're probably asking yourself is, well, why wouldn't you just do the IAEA authority, full IAEA authority? And the answer is because it is more expensive. In most circumstances, the court is going to require a bond, a probate bond. You can think of it like an insurance policy against malfeasance by the personal representative. When you have limited or no IAEA authority, the value of the real properties is not included in the calculation for the bond. So if we have a $1 million property and a $50,000 bank account, for no IAEA authority or limited, the bond would just be set off the value of the bank account's $50,000 bond. If we request full IAEA authority, the value of the real property, so $1 million, is included. And that drastically increases the cost of the bond. The cost of the bond is influenced in great part by the amount of the bond. And so as compared to a $50,000 bond, a $1 million bond would be much more expensive. Over here, this would probably be a couple $100 for a $50,000 bond, whereas a $1 million bond would probably cost $2,000 on an annual basis. And so for estates that don't have a lot of cash, or where the personal representative himself or herself doesn't have the funds to advance it, Often it's the case where you just have to deal with the limited IAEA powers.
Can I ask something?
Mhm.
Who gives that full authority? Is it just about the money? You pay more, so you get full authority?
Yeah, so it's a decision that's made on the front end. The personal representative will discuss it with their attorney, and they'll make a choice. They'll have to decide whether to request limited or whether to request full. And if they request full, then it comes down to whether the personal representative can qualify. So whether the bond company is willing to write the bond. So if we've got someone who doesn't have any assets and has terrible credit, the bond company is not going to write the bond. On the other side, if we have someone who's got a bunch of assets and really good credit, the bond company will be happy to write the bond. And so the answer to the question is the personal representative, the person who has gone to court to get appointed, they're the one who's going to make this decision in consultation with their attorney based on the relevant facts. You know, what's their credit, what are their assets, and do they have the cash to pay the bond?
So if a house is around $1 million, it's around $2,000.
Yeah, so that's kind of the scale. It's it's going to depend again. The amount of the bond is going to be the biggest factor, but the credit worthiness and the assets of the proposed personal representative are going to be another big factor. And then every bond company gets to choose what they want to charge for a premium.
And do they get this $2,000 back once the house is sold?
No, it's a premium. So it's just like an insurance policy. You pay the premium to the surety company, and then that's because they are saying the reason for the bond is if the personal representative sells the house, takes the money, and leaves, then now there's no money for the beneficiaries. And so the purpose of the bond is the beneficiaries then turn around to the bond company and say, hey, that guy just stole $1 million. You wrote the bond, so give me $1 million. The bond company will say, you're right, here's your $1 million, and then go after the personal representative. So it's an insurance policy. So the money's gone, it's spent. It's just an expensive administration. You don't get it back. Now, when I say you don't get it back, I mean the expense is borne by the estate. The personal representative, if he loans the money to the estate to pay the premium, the personal representative will get reimbursed, but the estate will be the one making the payment back. Does that make sense?
No.
So think that the estate is a collection of assets and liabilities. The amount available for distribution is assets minus liabilities minus expensive administration. And so if we start with a pot of $1 million, we've got $100,000 in creditor payments, we make those. There's going to be $50,000, $60,000 of expenses, and those get paid first. And so when I represent clients in probate, I advance some of the expenses. So like I pay the filing fees. Oftentimes, if it's a smaller bond premium, I'll just take care of it. And so all over the course of the administration, lend about $1,500 to my client, which then at the end gets paid back out of the estate before any of the heirs get their distribution.
Okay, thank you.
So, question. So if you go the court confirmation route, the process is long, right?
Yeah.
Okay.
Yeah, so we're gonna talk more about each process right now. So notice of proposed action. Again, this is full IAEA authority. The way that it works, and there's actually kind of a variation, but this is sort of the standard way to do it. So the way that it works is you put the property up on the market. So that requires a listing agreement to be entered into. We put the property on the market. We do whatever, we handle our business in a normal fashion. We get to the point where we get into contract and we open the escrow. Now, at this point, a notice of proposed action needs to be sent. So this is a document that is going to be prepared by the probate attorney. So the attorney who's representing the seller, which in this case is the personal representative, and that's going to get sent to all the interested parties. So essentially anybody who has a potential stake in that property is going to receive the notice of proposed action at least 15 days before the close of escrow. So that's point number one, is we're going to have at least a 2-week delay. So that's important consideration to make, whether you're representing the seller or the buyer. A very quick escrow period is not going to work because you need at least the 15 days. And adding on a couple days for the attorney to get this thing prepared and served, plus a couple days to be safe on the back end. You really don't want to be in a situation where you have written a short escrow and now you as the seller can't perform because you just made it too short given the circumstances. So step 2, the notice goes out to all the interested parties. Step 3, all of those parties get to decide whether to consent, object, or do nothing. So if they consent, that means you're good, you can move forward with the sale. If they object, then unfortunately you're now in a situation where court confirmation is required. And so we really want to make sure that we're doing a good job on the marketing and on the sales and making sure that we get the highest possible sale price, because we don't want that objection. Now we're in the worst of both worlds. We have just paid, the full bond to get that IAEA authority, but we're still in court confirmation land. So that is one potential risk, is that a beneficiary who's upset for some reason might not consent, and then if they affirmatively object, you end up in court confirmation. One situation, so just for example, I got a call this week about it was a young woman. Her parents had died. Her sisters, was 3 of them. They wanted to sell the house. She wanted to stop the sale, but she didn't really have a good reason. The house was going to be sold. If it's in most cases, if we have a single piece of real property, it's going to get distributed to 3 beneficiaries. It needs to be sold. Distributing it in kind, so giving them each a third of the real property and recording a deed, is just going to lead to trouble down the road, probably result in a partition action, eventually. And so in that circumstance, the property is going to be sold. She's, from an emotional perspective, she just didn't want the property to be sold. And therefore, she would have probably objected to a notice of proposed action because she didn't want it to be sold, irrespective of the sale price. The agent could have done as good of a job as possible, but given her emotional attachment to the property, someone in her position would likely object. And so this is a consideration for the personal representative to make on the front. And if we know we've got a beneficiary who's going to be litigious, basically, or just be in conflict with the personal representative, then notice of proposed action is probably not the right way to go, because it sends you right back to court, and all you've done is spent extra on the law.
Can I ask, who is considered interested parties?
Interested parties. So it's going to be anybody who, like in the situation I just described, where we've got 3 daughters, they're each going to be interested parties. If the will says, this property goes to, my cousin James, then James is the interested party. So basically anybody who, in the absence of the sale, would potentially end up with an interest in that real property is interested in that.
So just close family, not like all the cousins.
Yeah, it only the person who's gonna potentially end up with it. So not just anyone who's related, but somebody who actually has a stake in that property if it's not sold. And that's gonna be for the attorney to decide. The attorney will identify.
But why not send it to them before open escrow?
You could, yeah. So this is one way to do it, which is send the NOPA once the agreement is received. And so this has the benefit of listing the sales price. And then they can make an informed decision based on the sales price. The other way to do it is to send a NOPA out, and I've done this. So we just did this on a property where we did a NOPA on the sale. So we said the proposed action wasn't we're going to close this contract. It was we're going to sell the property. And so if you don't want the property to be sold, you need to object. And so that writing it that way removes the ability, like that example I just gave of the daughter who didn't want the property sold, is in a situation like that, you probably do something first, like we're going to sell the property, or we're going to list the property for sale, or whatever, however you want to word it. Give her 15 days, and then if she fails to object, well, then she fails to object. But then so that was in the trust context, and so the trustee has more powers than a personal representative. So when you have a beneficiary who wants to be difficult, it's just something you have to work around.
And this is sent by mail, the 15 days?
Yeah, typically it's going to be sent by mail, unless people have consented to electronic service.
And what is a good enough objection?
They don't need any reason, they just check the box object.
Object, and then they have to appear at court?
No, you then that forces the personal representative to go through with the
Court confirmation.
court confirmation.
Okay, and if they don't object, then you could just sell
If
it
they
as a
don't-
standard stuff.
So if they don't object, then that's deemed consent. So you either have to affirmatively object, but if you do nothing, it's deemed consent. Or if you want to speed things up, you can sign the consent.
So every time you see meets court confirmation, that means that somebody objected?
If we started on a notice of proposed action, no, so if we don't have full IAEA, then we know ahead of time that we need court confirmation. So the court confirmation process is as follows, and it's important for the agents to at least be cognizant of the process, because there's circumstances where the probate attorney's office, if they make a mistake, you might have to start the whole sale over again. And so here's kind of the biggest issue is the notice of sale. Notice of sale is you publish the intention to do the sale, not just in the MLS in the way that you would typically do, but it needs to be published in a newspaper, general circulation. And so this is something the attorney's office handles. It's very common, but it needs to be done before you get into contract. And so if you don't have those 3 publications before you get into contract, the judge is not going to confirm the sale. He's going to send you back, or she's going to send you back, and you're going to have to do it all over again. And so it's important as the agent to just be in contact with the probate attorney. Are we okay to get into contract? Is there a notice of sale requirement? Has it been satisfied? Then once you get into contract, so now we're between the first and second step here, it's up to the probate attorney to prepare the report of sale and petition for order. And so this is a form. I'll show you what it looks like in a couple slides. But basically this document is not going to be prepared and filed until we get to the point where all contingencies are removed and a total deposit of 10% has been made. Now, these are not rules in the sense that that's not in the probate code. But it's a custom, and it's an expectation that you should be prepared to meet. Right. And the reason is that filing the document with the court, number one, it costs money, and 2, it's gonna put a pause in the proceedings, because that petition is not going to be heard for at least 6 weeks, most likely, and maybe even longer, depending on the court's docket. And so the reason that all contingencies must be removed and 10% needs to go in is because we need to be at the point where all that's left is the judge saying go ahead, and then we're ready to close escrow. Both sides of the executory contract should be essentially completely performed, with the only thing remaining is the buyer fully funding the purchase price and the seller executing the transaction documents. So one point to be really careful of when you are representing a buyer in a probate context is they have to remove all their contingencies. So even if they're a conventional type buyer, owner occupant type buyer, and they're going to use just sort of conventional financing, as soon as they remove that contingency, they can no longer exit the contract. They can't cancel the contract because they can't get a loan. So you're putting your 10% at risk. Even if they don't qualify, they'll have to, if the property doesn't appraise or whatever, because there's going to be a period, you're not going to move forward with your financial, with the lender. And so all those things that would typically happen right before close are going to happen months after the contingency has been removed. So it's really important to make sure that your buyer has the ability to perform, or else they're going to lose their 10% deposit. And then when we get to the confirmation hearing, which again is going to be 6, 7, 8 weeks down the road, the judge will first make any necessary findings. So depending on the circumstances, the judge has to make the determination that the sale is necessary. And then they're going to do a courtroom auction. And so the purchase price in the sales contract is, you can think of it as the initial bid. So that's the first bid. And then the judge is going to say, does anybody else want to make a bid? There's an overbid amount, which is listed in the petition. And so if somebody wants to go in because the purchase price was too low and they still think that there's value at a higher price, they can show up to court and make a bid. They'll probably need to be qualified by the probate attorney to make sure that they have the funds. And so that would be, your basic proof of funds type thing, bring your brokerage statement. and then a cashier's check for the 10%. Okay, so the overbid is subject to a statutory formula. I'll show you that. That's the first overbid, so you can't, the judge isn't gonna mess around with like $1,000, $2,000. It's gotta be a good jump. The sale must be for at least 90% of the appraised value. And so part of the process, the probate attorney will be informing the personal representative, here's what the house appraised for. So if the probate referee thinks it's worth $1 million, the judge cannot approve a sale for less than 900. So things change, right? We've been in kind of a weird market here. So if you got your appraisal 18 months ago, it may or may not be the right number for today. If that's the case, you need to go back to the probate referee and get a reappraisal for sale that more accurately reflects the market conditions. Broker commission. So typically the broker commissions are just handled exclusively by the agreements between the parties and the brokers. Here, they are subject to court approval. So anything that's listed in your car forms can be potentially overridden by the judge's orders. In Los Angeles County, there's a local rule that says there's a cap that's 5%. In Orange County, it's 6%, and in Ventura County, there's no limit. Now, these rules that I have here, this is hasn't been updated in light of the new way that broker commissions are handled. I don't know if they're ever going to get around to it, just kind of given the way where we've ended up with typically the seller granting a concession for the buyer broker commission. But that's what the rule says now, is total commissions will not exceed 5%. Okay, any questions on the court confirmation process? See online. No questions. Okay, so this is an example of the report and sale, or should be report of sale and petition for order confirming. So this is going to be filed when we go to court, and so you can see. So the petitioner here, we've got the state of Mickey Mouse. Donald Duck is the personal representative. We're asking the court to confirm the sale of the real property. We need to lay out our commission, so that's going to be right there near the top. We're selling 100% of the property. It's improved. This is the address. Then we're going to, in paragraph 3, include some information about the appraisal. So this is I guess that should be a 1 million, was reappraised at 1.1. This is how the buyer is going to take title. This was a private sale. So private is what you guys do every day. Public is an auction. And then the sale price was 1.15, deposit of 115, and it's going to be all cash. And so when we say all cash, that means that the seller is going to get 100% cash. The seller is not going to receive a note and deed of trust back. And here's page 2. So we get into the brokers, broker A, broker B. We're going to split it evenly. So 50% to each. And then information regarding notice of sale, notice of hearing, reason for sale. The overbid formula here. So on a 1.15 sale, the first overbid would need to be at least 1.208. And so that's a pretty big jump. As you can see here, the formula is going to be $1,000 plus 5% of the purchase price over 10,000. So just as a loose rule of thumb, the overbid is going to be a little more than 5% over the contract price. And what that means is that oftentimes it's not really going to make sense for somebody to come in and overbid unless the purchase price is really low. Because think about it from an overbidder's perspective, is they have not done an inspection. They haven't gotten nearly as much information about the property as the person who has gone through a contingency period. And so to get yourself into a transaction like that, where you really don't have as much information as somebody else, is that contract price realistically would have to be pretty low, 85% of fair market value, in order for it to make sense for somebody to come in and take it. And frankly, it would most likely happen in a flipper type situation where they're coming in and really getting a good deal. And then the final point I'll make is in paragraph 12, the personal representative needs to detail the marketing efforts. And the reason for that is the judge wants to safeguard the estate's interest. So they want to make sure that this wasn't a total, off-market pocket listing that's getting sold to a cousin type thing. And so you need to do a good job keeping track, because the probate attorney is going to turn around and ask you, hey, can you give me some information on what we did? And so, it's basic stuff. It's not anything you guys don't do on the listing, but you just need to keep track of it, and the more detail, the better.
And the people who show up at court, they're not able to request to see inspection report and all of that.
No, they could. So if you knew ahead of time that you were interested in a property, you can certainly reach out to the attorney or to the listing agent and say, hey, I see you're in contract at $1 million, and I see the overbid is, 1.05. I'm interested in coming, would you mind sharing with me some documents? So I can try to attempt to do my diligence before I show up. Now, in that circumstance, it would make sense, right? Because the seller's agent, they want the highest possible purchase price. The personal representative wants the highest possible purchase price, so why not? If you've got the information, give it to them. But they are not entitled to it.
And the overbid is always gonna be 5% plus the 10% of first 10,000 of original.
Yeah, so it's always going to adhere to that. So just kind of roughly speaking, it's going to be a little more than 5%.
And then the second bid the same?
No, the second bid, the judge. So in this circumstance, right, if I was a judge, I would probably say overbid. So second bid's got to be at least, whatever, 20 grand. It's not going to be, we're not going to be doing bid increases of 100. But the judge gets to pick. So the first, in this example, if you want to come in and take this deal, you have to bid at least 1.208. And then from there, again, it's up to the judge. The judge might say 5 grand, 10 grand, 20 grand, 50
But it's
grand.
not 5%.
It's not 5%, yeah, because then we're 10% over.
Yeah, too much.
Most cases, that's going to be too much. Okay, so any questions? So that was the legal process, and now we're going to kind of switch gears and talk about the car forms. Okay, so then we'll start. We're going to go to the very beginning and talk about the listing agreement. So the situation is somebody comes to you, my mom died, my dad died, we need to sell the house. What do we do? There's a ton of work that needs to be done on the legal side, and we just talked about it all before we get to a listing agreement. So number one, when you are potentially going to represent the personal representative, do not jump right to a listing agreement, because it's just completely out of order. They need to go to court first. Somebody needs to be appointed personal representative, and they need to have their letters. And if they don't have their letters and they can't show you their letters, then there's no reason signing a listing agreement, because it doesn't matter. They don't have authority to sell the house. And so typically, the first, a lot of times you guys are the first point of contact. Is the family. They know they need to sell the house, so they call an agent. You guys need to be directing them to a probate attorney. So I'm happy to take the call. If you have a probate attorney that you work with, point them in that direction. And they need to get going on the court side of things, because they're just not in a position to sign a listing agreement until several months into the process. But when we do have letters and we are ready to sign a listing agreement, we're just going to use the regular, RLA. I prefer the representative capacity signature disclosure because it just has more information and it's more clear, but you don't have to use it. The RLA has an entity seller, so you can check a box and add a little bit more information. But I just think the representative capacity signature disclosure is cleaner and has more information. But again, so that'll be up to you. And then you'll need the probate listing addendum and advisory. One thing, if you haven't used the representative capacity signature disclosures, is there's two. There's separate forms for seller and buyer. So make sure you're using the -S on the listing agreement. Okay, so then a couple other things to keep an eye on is if your seller has limited or no IAE authority, they need to have court permission to enter into an exclusive listing agreement. So you guys want exclusive listing agreements. You don't want open listing agreements. And so that's a question, is you need to ask do you have authority to enter into an exclusive listing agreement? It's pretty easy to get it if you don't have it. It's just a quick ex parte petition, but it needs to be done. It's just one of those legal requirements. If your seller does not have authority to enter into an exclusive listing agreement and nevertheless enters into one with you, you simply will not be able to enforce that agreement against the estate. And so one place where this would come in is if you take the listing, you go through the whole thing, you identify a potential buyer, then you get fired and I forget what it's called off the top of my head, but you provide the seller with that,
With a list of the buyers.
with a list of the buyers, yeah. So you provide the seller with that list of the buyers, then the transaction closes with one of those buyers, and you circle back and you want to protect your commission. If your seller did not have the authority to enter into that exclusive listing agreement with you, you're out of luck. You entered into a contract with the party who lacked legal authorization to get into such a contract, so you wouldn't be able to enforce that against the estate. Your sole means of recourse would be against the personal representative himself or herself, which is a bummer. So be careful, don't get into a listing agreement with somebody who doesn't have legal authority to do so. For you guys, obviously, this is a legal determination, and so the easiest way to handle it is just ask the probate attorney, can we do an exclusive listing agreement? Does the client have authority to enter into one? Okay, and so then here's the signature disclosure, and again, I like it because it's more comprehensive. It has the various scenarios laid out, and so this is an estate, so it would be here. Click estate of Mickey Mouse, and the case number, and then the seller is the executor, and so we would just use their title. The probate listing addendum, and so this is just laying out some additional information. So you can see here, number one, we're part of a probate estate. Number two, the listing period is 90 days. And so in a probate context, you only get 90 days. Anything longer, it simply will be overridden by this addendum. Court confirmation. So if you know it's required, you would check the first box. If it may be required, check the second box. Four, I would not recommend doing a pocket listing in a probate context. It's just going to be kind of a recipe unless it's a unique situation like an extremely high value house and an extremely good potential sale. Then paragraph 5, I mentioned that broker compensation is subject to the court. That's what paragraph 5 says. Paragraph 6, dispute resolution is deleted in its entirety. So most CAR forms, if not all, have dispute resolution paragraphs, mandatory mediation, mandatory arbitration. That is out for a probate transaction. The court will have jurisdiction over any dispute arising from the agreement. And that's basically it. Paragraph 8 has a indication regarding title. Typically, you can probably just leave that blank. All right, probate advisory. So this just has some additional information about probate sales for the benefit of the seller. One common misconception is related to disclosure requirements. And so it's true that in the probate context, the personal representative, so the seller, has fewer disclosure requirements than a conventional seller, but they don't have no duties. And so you can see on the first 3 under exemptions. So these are things that don't need to happen. So we don't need a transfer disclosure statement. We don't need the natural hazards disclosure statement. And we don't need the Mello-Roos disclosure. We don't need to either provide the earthquake guides, and we don't need the smoke detectors. Why? Who knows? That's just what the law is. What we do need to do is make a exempt seller disclosure. And so there are duties for a seller to disclose all known facts that are material, right? And so the seller doesn't need to go do an investigation, but if they walk into the house and the first story bathroom is flooding, and they hire a plumber to fix it, well, they need to disclose that because they have personal knowledge of that particular condition of the property. And so that's the kind of thing that would be included on the exempt seller disclosure. And then you can see going down from 1 to 7, the other types of disclosures that do still need to occur. So you'll notice water heaters, those are still, the water heater strap is still required. Why is the water heater strap required, but the smoke detector's not? Who knows? This is what it is.
Is in probate always sold as is, or can you ask for like repairs or seller credits?
So you can ask for whatever you want. If now you can do that. The way I think that sales should typically be handled in a probate context is you don't always have to do it, like an investor type sale where it's just as is, the price is the price. You can try to market it as an owner occupant property. And if you do so, yeah, you're probably going to end up, and it's obviously going to depend on the condition of the property. But you can run it like a regular sale, and during that contingency period, you can negotiate over credits. But at some point before we go to court, we're going to be all contingencies removed, 10% in. At that point, it's too late. So you can negotiate about that stuff before the petition is filed. But once you're done, so I guess the answer is sure, if it's appropriate, during the contingency period, those things can be discussed. But after, yeah, good question, Anthony. So how do you satisfy the hazard zone? The answer is that just let escrow do it. It's not a huge deal, and frankly, it'll run smoother if we just sort of run it like a conventional sale. Because then nobody's concerned that we're not following the rules. It really comes down to, is required? No, but does it just sort of make sense to just kind of run it the regular way? I would say probably, right?
So the 10% deposit, so in a standard sale, you have to give like 1 to 3%. In a probate sale, you have to put down 10%?
You don't have to. Like I said, there's no rule that you have to, but if I'm representing a personal representative, we're not going to court until somebody has 10% in and all contingencies removed.
Okay.
Because now we're taking the property off the market, so to speak.
Okay.
Not really off the market, but I'm not going to spend attorney hours and incur a filing fee until somebody is we just need to close. That's all that's left. And so the buyer is just going to have to come up with the cash. And so certain kinds of buyers just simply aren't going to be in a position financially to take part in a probate type transaction.
So as a buyer, when you make an offer, you should give 10% deposit to be accepted?
No. I would start, if I was writing an offer, what I would do in a probate context is I would start with, your regular earnest money, due within, upon signing the contract. And then I would check the box for additional deposit. So get to 10% of that additional deposit, but when all contingencies have been removed.
Okay.
So, do your normal thing, and then instead of no additional deposit, just wait for close to fund the balance of the purchase price, is increase the 10%. So that gives your buyer the opportunity to go through the typical diligence, and if they really want the property, yeah, they gotta put up the other 7% and wait.
Thank you.
Okay, and so this, again, this is the probate advisory, so just kind of finishing up. So we were talking about disclosures, brokers, same rules. You've got to do your avid, you've got to disclose what you know. And so, treat it like a normal sale. Then court confirmation, court jurisdiction. So this just lays out more or less what we've been talking about. The standard provisions in the purchase agreements, our purchase agreements are going to get overridden by these. So liquidated damages, mediation, arbitration, those just aren't going to be a part. Okay, any question about the listing package? Okay, great. So then let's move on to the purchase agreement. So thankfully, CAR has made it easier. There used to be a probate specific purchase agreement, and that created an issue where, because obviously the buyer's agent writes the offer and they're not paying as close attention. They would just use the standard purchase agreement, and then you'd have to counter with the probate purchase agreement to get all the probate specific terms in. They have solved that problem, and so you'll use whatever purchase agreement is appropriate, and then you'll add the probate agreement purchase addendum. And so the Form PAPA has all the probate specific language. It is critical. It is 100% absolutely critical that you use the probate agreement purchase addendum because of the nature of probate sales, whether it's NOPA or whether it's court confirmation. If you just use the regular purchase agreement and the transaction kind of gets a little bumpy, goes sideways, whatever the case, there is simply not going to be sufficient.
Listen to that joke the man was telling us.
Someone mute
Just
themselves.
a comment.
Yeah, so you absolutely need the probate agreement purchase addendum. So on the RPA, all you need to do is just check a couple boxes. So there's a box for the probate agreement purchase addendum, and then there's a box for the probate advisory. So that's very straightforward. Just check those boxes and you're good to go. And then the probate agreement purchase addendum. So you don't have a whole lot to fill out here. Obviously, the identity of the parties up top, and then getting it into paragraph 1. If we're in a probate, we don't have to check anything. The default is a decedent's estate, which is what we want. These forms would be used for guardianship, conservatorship, or receivership. So if that's appropriate, check the box. And then it just gets into some basic information, which we'll go through quickly. So it's being sold as a part of a decedent's estate. It's being, and then C and D just talk about which paragraph we're going to be under in terms of confirmation. So incorporate the probate advisory, and then we get down to court confirmation. So if court confirmation undetermined at time of offer. So this would be the NOPA, right? Because we may still end up in a court confirmed situation if we have a NOPA. So therefore, we do not know if court confirmation is required. So the first thing is that the seller has an obligation to tell the buyer at some point when court confirmation is required or not. So I don't suggest you do acceptance, and instead I would just do within the time for seller delivery. So this will relate back to the seller documents in the purchase agreement. And this creates an affirmative obligation on the seller to inform the buyer when court confirmation is required or not. So if court confirmation is not initially required, notice of the terms of the sale to the beneficiary's heir is still necessary. If any beneficiary or heir objects, then court confirmation shall be required. So this is explaining the NOPA process and making it very clear that if somebody objects, we have to go to court. Seller has an obligation to promptly deliver written notice to the buyer if they receive an objection. So this is important. You can't sit around and wait. If your seller gets an objection to their NOPA, you need to tell the buyer. Once you're in contract, if court confirmation becomes required, this is important, because of an objection, then buyer has 3 days to cancel and shall be entitled to return of their deposit. So if your buyer, the reason this is important is because you as the agent, you got to be the one, this is your agreement. You have to be the one advising your client. If you think you're going into a NOPA sale and there's not going to be any court confirmation, you get into contract, your buyer makes their deposit. If it then switches to court confirmation because a beneficiary has objected, you only have 3 days to get out. So if you're in a situation where all of your other contingencies are removed and you blow that deadline, you're in it. You're in the contract. You no longer have any rights to cancel or get out. And so again, very important when you are representing a buyer and you think it's a NOPA and you receive notification that a beneficiary has objected. And so now it's therefore a court confirmation sale. If your buyer doesn't want to do that, doesn't want to sit around for the 2 months and waiting and potentially have the overbid, that's fine. They have the right to get out. but they only have 3 days. And if you wait the 3 days, you no longer can cancel the contract for that reason. So again, if your other contingencies are, haven't been removed yet, or if you have been removed, then this might be your only way out.
And 3 days are counting, like if today you receive it, is tomorrow day one?
Yes. Yeah, so Monday you receive notice, Tuesday, day 1, Wednesday, day 2, Thursday, day 3. So by, I forget exactly it's in the probate agreement, how to count days. But so Thursday would be your last day.
So by Thursday, by midnight, you have to.
I don't want to say because I haven't looked at that part of so go back to the purchase agreement and look at the counting days, provisions, they're buried in there
Yeah,
somewhere.
it's in there, yeah.
Okay, so that's just the practice point there. It's just make sure that you're talking to your buyer and you're letting them know they can get out. And then paragraph 3B, if you know ahead of time that court confirmation is required, this would be checked. And so typically, the way the order of operations would be is somebody's going to write an offer on the residential on the RPA, and then if everything's good, right, you just want to take it. You would still need to counter with the probate agreement purchase addendum to layer on these additional provisions that are going to be necessary. Okay, so then court confirmation is required. So this just adds some additional details. And so this obligates the seller to file the petition. So someone's got to file it, and technically anybody can file it. The seller is the one who, the overwhelming majority of the time, files it. But if the seller doesn't, for whatever reason, the buyer can file it too. This affirmatively requires the seller to file the petition. The seller needs to give the buyer written notice of the hearing date. 15 days is the standard, so I would just leave that unchecked. Then we've got some CYA type language. Broker recommends that buyer show up and to protect their position in the event of overbidding. The probate code may require legal notice to be published. So we talked about this as one area where there's a big potential to make a mistake. If you are required to publish notice of the sale and you don't, the sale is not going to get confirmed. And so if publication is required, buyer understands that seller is unable to accept buyer's offer until after the expiration of the notice period, yada, yada, yada. So if we mess this up, acceptance of the offer prior to publication is voidable. And so where you mess this up, publication was not done properly. We got into contract before publication. We go through escrow, we do all our inspections, we remove all our contingencies, we get our 10% in, we file the petition, we go to court. And the judge says, you guys messed up, you got to do it again. Even after having removed all their contingencies and placed their 10% in, based on this highlighted language, the buyer, it can now void the contract and get their money back. And so the seller screwed up, they messed up the publication, and they've granted essentially an option to the buyer, an additional contingency, an additional right to exit the contract. Why is it that it needs to be published? Because the probate code says so. It's a legal requirement. You can think of it, the probate code was, this requirement was created, back in the sort of pre-MLS days. And so how do you know a property was for sale without the MLS? You put it in the newspaper. And it's just kind of a vestige. Does it really do anything? No, nobody reads those notices. The MLS is a much more powerful tool to promote and market and advertise your property, but that's what the probate code says.
Who has to publish it, the attorney or
The attorney. So the attorney's office will just, it's a very easy thing. You just email it to a vendor who handles it and then publish it. It's not a big thing, but it is just a box.
So attorney will do it, or you have to tell him that?
No, the attorney should do it. An attorney who knows what they're doing should handle it. Okay, so then we get to the 90% rule. So we know about that. And then I don't love this paragraph. It's there. I don't know that it makes a lot of sense. So seller may remove property from the court calendar if buyer has not removed all contingencies at least 10 days before prior to court confirmation hearing date. The reason I don't like it is because like I said, there is no way that I'm preparing and filing a petition unless all those contingencies have been removed. I mean, there's just, if the buyer can get out on an inspection contingency or a loan contingency or an appraisal contingency, why are we creating, signing and filing a legal document? So to me, paragraph 4B is just never going to come up because we're not going to court until all contingencies have been. Okay, the one thing is that the court needs to be informed of how title is going to vest. This is one of those funny requirements. It probably is not a big deal in most circumstances, but sometimes if you've got an investor buyer or whatever the case may be, the judge will not grant a petition until you affirmatively tell the judge how title is going to vest, because that's part of the order, you know, that the personal representative is only authorized to transfer title to whoever, you know, the court says so. And so paragraph 5, this is an easy way to take care of it before you even get into contract. It doesn't need to be designated, so you can see the next sentence. Investing is not designated above, and the buyer has 10 days to designate how title will be taken. And then again, we've talked about it several times, dispute resolution is out. Any questions about the form PAPA? All right, so then I want to call out the very last page of the form PAPA concerns an agreement between the brokers. So typically, right, the buyer and the seller are the ones who are parties to the contract. And the brokers, yes, your name is on there, but you're not actually a party. We're just identifying you for the convenience of the transaction. This little box at the end of form PAPA is an agreement between the brokers. And what it says is that the seller, excuse me, the buyer broker, it says that the buyer broker identified in the purchase agreement, so the person whose name is on page 1 of the RPA, they agree to waive all commission rights in the event of a successful overbid. So seller is A, broker A, buyer is broker B, overbidder is broker C. If we end up in a situation where the overbidder wins, so therefore broker B's client did not end up with the property, if you sign this agreement, excuse me, both agents sign this agreement, then the buyer broker B has waived their rights to the commission. And you might think, well, my buyer didn't end up with the property, why would I have any rights? And the answer is because the probate code actually does give a broker in that situation rights. So again, broker A and broker B, their clients get in a contract, you go to court, broker C's client wins the auction and ends up being the buyer. The probate code in that circumstance says that broker A and broker B are entitled to some commission. But if you sign this, you waive that commission. And the reason is that the reason that the probate code says that broker B here would be entitled to commission is because you've gone through the whole transaction. You represented your buyer, you got in the contract, you went through the contingency period, we got to no contingencies left. And now we're just waiting on the court. So you've basically done all the work. And then because someone else has come in and taken the deal, the probate code would still give you a slice of the commission.
How much usually?
Half. So the way it goes is in the situation where all three parties, so it's really complicated because there's three potential parties, and they each may or may not be represented by a broker. But in the situation where all three are represented by the broker, by a different broker, the way it would work under the probate code. So this, nobody signs this. The probate code says that the half of the commission on the original sale price. So we get into contract for $1 million, you know, using 5%. So that 25,000, that would typically go, you know, 25 to each side. The selling agent and the initial buying agent split half. So 12,500 to the seller's agent, 12,500 to broker B, the losing bidder's agent, and then the winning agent gets the other half, 25,000. And that's on the original, that's the commission on the original sales price. If the sale closes at 1.2, then we still have the 5% commission on the 200,000. So then that all goes to broker C.
Well, so if it closes for more. The seller and buyer agent, the initial ones. They get more commission now because it's sold for a higher price.
Well, so it depends. If you sign this and the ultimate sales price after the auction is 1.2, then the total commission is gonna be 60,000.
Yeah.
And so each side will get 30.
Yeah.
If you sign this, broker C will get 30 because they represented the winning buyer. And broker A, as the selling agent or the listing agent, will get 30. If you don't sign this, then under the situation we just described, listing agent gets 12,500. Broker B, the agent who got under contract, will get 12,500. So that's 50.
Uh-huh.
And then the other agent will get the 25,000 plus another
Uh-huh. Yeah,
go to 5,000. Right?
so it's better to sign this?
If you're the listing agent, you want to sign this because then it protects you in the event of an overbid. Because you're still going to get your full commission. If you're the buyer's agent, do not sign this. Because then if you get overbid in court, you've just done all the work. You literally, right, you got into contract. We did inspections. We did, all contingencies removed. We sat around and we waited weeks for the court hearing. And then somebody comes in and steals the property and you end up with nothing. Well, why? What did you do wrong? You didn't do anything wrong. So if you are the listing agent, you really want this to be signed. If you are the buyer's agent, you really do not want this to be signed. And the only time it's going to matter is if there's a successful overbid in court. And so then it just gets into, you just get into the situation where you're potentially in conflict with your client. Because if they may hold up their signatures, the seller, again, so the buyer's broker doesn't want to sign this. And so you don't want to put yourself in a conflict with your client, the buyer. And so you have to make a business decision on whether you're willing to put your commission at risk. But I think if you explain the situation to your buyer, they would, probably come down with, on your side that it would be unfair. And the other protection you have is if the purchase price is so high that just realistically an overbid is not going to be feasible, then you can just make the business judgment of whether you're willing to bear the risk and just be confident that it's not actually going to come to fruition. Okay, and so that is it. Again, I'm Robert Theofanis. I'm a trust and estate attorney. I handle these types of legal matters, estate planning, post-death administration, and trust and probate litigations. And I can stick around if anybody has any kind of related questions they want to put in the chat.
Thank you.
Absolutely, thank you.
I do have one more thing.
Okay, let me just make sure for the folks online, I'm gonna stop the meeting here in a minute. So if you got a question, to get it in.
All right, thank you.
All right, thank you, guys.